For motion to bind over, I believe that the facts set up everything that's needed for count one, as it clearly shows that it's a substance, controlled substance, it's cocaine. It was tested by the True Narc. In this case, Officer Hussein had testified about finding the narcotic residue inside the vehicle. Then the two larger bags, which were found at the hospital. In this matter, the defendant was the only one in the bathroom at the time in which these narcotics, or prior to these narcotics being discovered. He was informed not to flush the toilet, did so anyway, was also informed not to basically make sure that he could be visualized. In this case, he saw that he bladed himself towards the trash can away from the view. There was fervent movements with his hands. And then all of a sudden there happened to be, while he washed his hands, there's two baggies of one bag of cocaine, one bag of crack. It just happened to be wet at the time in which generally right after he washes his hands, Your Honor. So it's been tested and shown as far as count one is concerned. But when it comes to count two, Your Honor, I believe...
Let's skip the formalities. This case is no joke. The evidence? Rock solid. Lab tests didn't just hint at cocaine, they confirmed it. We're not talking about a hunch. We're talking about tested, tagged, and officially tracked narcotics. Officer Hussein also spotted drug residue in the car, which raised even more red flags. Things took a dramatic turn at the hospital. Not one, but two separate bags were discovered. And the suspect? He ignored clear instructions and dashed into the restroom. Moments later, hospital staff found him suspiciously lingering by the trash, and shortly after, two soaking wet baggies turned up. Both were packed with cocaine and crack. The timing was just too perfect. It practically screamed connection.
Officer Hussein's testimony is very relevant into the indications of narcotic trafficking in cells. It's our position, Your Honor, based on the fact that there was a scale there, multiple small baggies for numerous small baggies for packaging, tear-offs, which are commonly used as packaging, two different types of narcotics placed in two different bags, both of which are above the normal use for personal use. In this matter, we have one at 14, I believe one at 30 grams, Your Honor. One of those, I believe, which would be the cocaine, this pure cocaine, Your Honor, 30 grams, that's over an ounce. He had over an ounce of cocaine and then approximately half an ounce of crack cocaine, Your Honor, with baggies, with the scale. Those are every single thing beyond our address book that one would need for distribution, Your Honor. So we do believe that there is more than enough probable cause to sustain the additional charge that the people had requested, which was...
Now here's where it gets heavy. This isn't about someone getting high on the side. It's trafficking. Officer Hussein laid it out clearly. Digital scales, tiny baggies, and packaging gear were all recovered. Classic street dealing paraphernalia. And we're not just talking one drug here. There were two. Cocaine and crack, kept separately and packaged for the streets. The stash included over 30 grams of cocaine and nearly half an ounce of crack. That's way beyond personal use. When you line up the quantity with all that packaging, the intent to sell is clear as day. There was more than enough to justify probable cause. This wasn't petty possession, it was full-scale distribution.
A possession with the intent to deliver, which would be a delivery of manufactured and controlled substance less than 50 grams. We showed that the total weight of this was 45 grams, Your Honor, just under that 50-gram threshold, and that it was all cocaine or a mixture that contains cocaine, Your Honor. So for those reasons, and of course, we've already established venue, time, location, and identity. So, Your Honor, at this point, we do ask that the court bind over on the original count one and the added count two of delivery and manufacturing of a controlled substance less than 50 grams.
Thank you. The first element of this, of course, is that the defendant possessed controlled substance. In this case, the allegations cocaine and crack cocaine. There was a pat down and a full search before the hospital, before any of these allegations happened, by trained law enforcement officers. They know how to do the searches.
But let's hear the other side. The defense isn't staying quiet. Their argument? When the suspect was initially searched, he had nothing on him. No drugs in his pockets, No traces in his system. Clean as a whistle. That's their key point. They say if he had nothing before he got to the hospital, then how could those drugs end up in that bathroom trash? The restroom was public, unsecured, and lacked any surveillance. Anyone could have walked in. Their story is simple. Those baggies? They could have belonged to anyone.
Well, Officer Colorasi was in training, but also trained to do a search, obviously. Nothing was found on my client's person. Nothing in his system from the blood draw. No drugs, no alcohol. So really the possession comes down to these two bags that were found in the trash can in the hospital bathroom. A bathroom that is open to the public 24/7, doesn't require any special entry. Anyone could walk into that hospital and use that bathroom. I was curious how often they cleared the trash can, but the officer from the hospital didn't know. So obviously those bags could have been there for any amount of time. The officer from the hospital testified that my client had irregular hand movements.
Still, the prosecution isn't buying the coincidence. Yes, the restroom was public, and yes, technically anyone could have dropped those bags. But here's what raises eyebrows. The suspect spent an unusually long time drying his hands. It didn't look like casual hygiene. It looked like stalling. Hospital staff noticed the odd behavior. No one saw him actually toss anything. True, but moments after he left, 2 wet baggies were pulled from the trash, bags freshly soaked, like they'd just been disposed of. The timing wasn't just suspicious, it was suspiciously perfect.
At the end of the day, all he said was, well, he was drying his hands for an irregular amount of time or something to that effect. I mean, that's, I just don't think there's a lot there to support probable cause, respectfully. And no one saw my client put anything in the trash can. And of course, Your Honor knows there's 2 types of possession, right? Actual and constructive. Presumably the people are arguing both, that he actually possessed these, but that nothing was found on his person. Constructive possession is, of course, and then there's case law, I think Mr. Danner is aware of. There's a Sixth Circuit case interpreting Michigan law, and then there's a Michigan Supreme Court case, and I have the citations, I'll mention them quickly, but basically proximity to contraband is not sufficient proof for possession, for constructive.
And now, we're in the legal trenches. This is where the defense flexes their muscle. They argue that in Michigan, just being near drugs doesn't prove anything. You need more than proximity. You need control, ownership, or clear intent. They've backed this up with solid legal precedent, citing cases like Parker versus Reno and People versus Wolf. The takeaway? No fingerprints, no eyewitnesses, no direct tie to the drugs. Without a definitive link, they argue, there's no constructive possession, just speculation. And under Michigan law, that's not enough.
There has to be something else connecting a defendant to the contraband, whether it's a weapon or a controlled substance. And I won't go through a lot, but I would just like to, for the record, say that I'm referring to a Sixth Circuit case, Parker v. Renico, 506 F3rd 444, interpreting Michigan law, decided October 17, 2007. And that case cites many cases, including a Michigan Supreme Court case, People v. Wolf, WLFE 440 MISH 508, decided in August 31st, 1992. Very briefly, what the Sixth Circuit says is, as with the federal rule, a person has constructive possession if there's proximity to the contraband, together with indicia of control. In other words, proximity alone never suffices. Cites the Michigan Supreme Court case. And
let's be real. This isn't some made-for-TV drama. This is real life, and the defense is driving that home. Their stance. No one saw the suspect throw anything out. No prints, no confession, just suspicion. And suspicion isn't evidence. They're hammering home the difference between actual and constructive possession. Even for the latter, Michigan law demands real proof. Just being close to the drugs doesn't cut it. The suspect may have been nearby, but unless there's a solid connection, the defense argues, there's no case. That doubt they're raising? It could be enough to shift the outcome.
The ultimate question, according to the Michigan Supreme Court, is whether the evidence establishes a sufficient connection between the defendant and the contraband to support the inference that the defendant exercised dominion and control over the substance. That's beyond the mere proximity. So I would respectfully assert that there is not probable cause on that first element for actual or constructive possession. The second element, defendant knew that he possessed a controlled substance. That would have to be inferred. There's no evidence of that. There's no statements or admissions. So that would have to be inferred from the first element. And, well, there is testimony of the weight. So that's the third element. So for all those reasons, well, I'll leave it at that. Thank you.
I really don't need rebuttal.
Now let's talk decisions. The judge has spoken, and it's not in the defense's favor. The court ruled there is probable cause, meaning there's enough credible evidence to believe the suspect had those drugs and meant to sell them. The judge highlighted several crucial factors: the packaging, the odd behavior, and the eyewitness accounts. Put together, it meets the legal bar to proceed. Sure, the defense raised valid concerns, but the judge said that's for a jury to sort through. Bottom line, this case is moving forward. No early dismissal, no walkaway moment.
The court would find that the people have sustained their burden of showing sufficient evidence that there's probable cause to believe that the defendant committed the offense of possession of a narcotic less than 25 grams. Also, given all of the testimony, in particular that by Officer Hussein, there is enough. This court believes that the defendant should also be bound to stand trial on the additional charge of possession with intent to deliver a controlled substance less than 50 grams. And so the court would bind the defendant over to circuit court on both those counts. The court would also indicate that the issues that are raised by the defendant with regards to those cases and actual possession, the court does find, for the purposes of probable cause, that those particular prongs under either test are met. To the extent there might be an argument as to what could be inferred or the intent, that this court would believe would become a question of fact that would properly be before the jury. But I think there's enough there to bind the defendant. Well, I know there's enough there to bind the defendant over. Defendant's bound over on counts 1 and 2.
And here it is, the official next step. The court has formally pushed the case to circuit court. Both charges, possession and possession with intent to deliver, are headed to trial. The defense gave it their all, but the evidence held firm. The timing, the testimony, and the stash. The judge wasn't swayed by legal maneuvering. This isn't about maybe anymore. The court believes there's enough here for a jury to decide. The case isn't ending, it's just heating up.